If I can just say a few words about Center for Justice, we're a non-profit, independent, non-governmental and non-partisan organization, and our mandate is to promote and protect the rule of law, human rights and civil liberties in Bermuda. We came into existence in 2011, and at our very first meeting, we decided to review the legislation on stop and search powers because I shared the story of a young black man who had come to see me after being stopped and searched 9 times between October 2010 and May 2011. This young man has a university degree and has a very good job. He does not fit your typical profile of a criminal or a gang member. When I asked him why he had been stopped and searched, he said he did not know, nor did he know under what authority he had been stopped and searched. Basically, the aim of Section 315F of the Criminal Code Act is to enhance the power of the police to stop and search in anticipation of violence. The powers conferred by this section can only be exercised at a place or locality that has been identified as a place where serious violence may take place. Authorization must be given by a police officer of or above the rank of inspector who reasonably suspects that incidents involving serious violence may take place in any locality and that it is expedient, and I repeat, expedient, to give an authorization under this section to prevent their occurrence, or that persons are carrying dangerous instruments or offensive weapons in any locality without good reason. The authorization allows any police officer in uniform to stop and search any person or vehicle, driver and passenger alike, for offensive weapons and dangerous instruments within the geographical area covered by the authorization. Section 315F specifically allows the police officer to stop and search anyone or any vehicle he thinks fit, whether or not he has any grounds for suspecting, and if I can repeat that, whether or not he has any grounds for suspecting that the person or vehicle is carrying weapons or articles of that kind. We say that this section is unconstitutional. It guarantees that we will not be subjected to a search of our person or our property without our consent or unless the search is authorized by the authority of law. Our right to privacy, guaranteed by Section 7 of the Constitution, is essentially aimed at protecting us against arbitrary arrest. Section 7 of the Bermuda Constitution goes on to say that the law in question will not be held inconsistent or in contravention of the law if it is reasonably required in the interest of public safety and public order or for the purpose of protecting the rights and freedom. We say that Section 315F is not proportionate to the interests of public safety. We say that because Section 315F empowers the senior officer to authorize any police officer in uniform to search anyone or any vehicle in areas specified by him that falls within his jurisdiction if he considers it expedient for the prevention of crime. Expedient means no more than advantageous or helpful. There's no requirement at the authorization stage that the stop and search power be considered necessary. Therefore, no requirement of any assessment of the proportionality of the measure. In Bermuda, our data is scant, but based on a sample survey conducted by the police in 2010, it was found that those stopped and searched were 5% black and white, 10% white, and a whopping 85% black. One of the issues that arose was that as a direct result of the 315F stop and search powers, and again, I remind you that under that section, the police are allowed to stop and search people and cars for weapons, nothing else, right? There had been an increase in the number of young black offenders who had been stopped and searched. No weapons found on them, but they were being prosecuted, guess for what? Small possession of marijuana. We were comforted by the then minister and the police that the cautioning guidance issued under PACE, Police and Criminal Evidence Act, allowed the police to caution first-time offenders. Section 6(1) of the amendment proposes that no person shall pursue a persistent course of conduct which amounts to harassment of another person based upon age or any grounds set out in Section 2(2). Those grounds are, we've all heard about it, race, national origin, place of origin, sex, disability, and so forth. Subsection 1, which I just read, does not apply to a persistent course of conduct if the person who pursued it showed that it was pursued for the purpose of preventing or detecting a crime. That's law enforcement. It was pursued under any enactment or rule of law, and that's Section 315F, or to comply with any condition or requirement imposed by any person under any enactment, or in the particular circumstances, the pursuit of the persistent course of conduct was reasonable. The overall aim of this piece of legislation is to eliminate discrimination and to provide a remedy to those who have been discriminated against under the Act. We've come to the conclusion that while Section 6(1) makes harassment by persistent course of conduct a breach of the Act, but then goes on to permit harassment by law enforcement, it is irrational and has no place in a democratic society. We've taken, as I said, we've taken independent legal advice from Queen's Counsel, and he has advised that this section also breaches Section 11 of the Bermuda Constitution, which guarantees the right of the enjoyment of movement, that is to say, the right to move freely throughout Bermuda. By authorizing or condoning a persistent code of conduct which a reasonable person would think amounted to harassment is not justifiable in a democratic society. And if the disproportionate number of young black men who are stopped and searched under 315F is anything to go by, then we can assume that Section 6(3) will have a similar disproportionate impact on the black community. And if that happens, then that would also be a contravention of Section 12 of the Bermuda Constitution. In conclusion, I would also like to say this. It is very, very difficult in Bermuda to advance or improve social justice because we don't have, like these other jurisdictions, we don't have a proper data. So whenever you want to advance an argument, what comes back to you is that, oh, you're just being emotional, or, well, where's the evidence? Oh, that's, and everybody comes up with always some exception to the usual experience that you're trying to talk about. And I think it's important for us to understand that the Human Rights Commission does have certain powers. And once CURE was abolished, the Human Rights Commission now has the power, has a statutory power to go about and collect data. And I think it's important for us to ask the Commission to at least carry out certain kind of investigations so that they can provide us with the data that we need.